Dear students, I welcome you to yet another lecture on corporate law. The topic of discussion for today's lecture shall be promoters. In this lecture, we shall try and understand the meaning of the term promoter. We shall also try and understand the rights and liabilities of a promoter. We shall also try and understand the legal position of the promoter in a company. When an individual has an idea for a new business venture, he or she may set about interesting others in the venture and try and persuade them to contribute capital to a company to be incorporated for the purpose of carrying on the venture. The individual then shall be described as the promoter of the company. A person who acts in a professional capacity is not a promoter. A company is born only when it is duly incorporated. For incorporating a company, various documents are to be prepared and other formalities are to be complied with. All this work is done by the promoters. The question then arises, who really are the promoters of a company? The most important work of a promoter is in the formation of a company. The whole process of the formation of the company may be divided into 4 stages. Number 1, promotion. Number 2, registration. Number 3, flotation. And number 4, commencement of business. Promotion is a term of wide import denoting the preliminary steps taken for the purpose of registration and flotation of the company. A promoter may be an individual, a syndicate, an association, a partner, or a company. The promoter is usually an industrial expert who, with the help of a big team of experts, does the entire preliminary work necessary before a company can be brought into existence. He selects and settles with persons to become signatories to the memorandum and the first directors, instructs and directs the solicitors to prepare the memorandum, the articles and other necessary documents to be filed with the registrar of companies, finds funds for the registration expenses and prepares the climate to secure the initial capital for the company, where to situate the registered office of the company and from where to get the necessary plant and equipment etc. are the other worries of a promoter. Whether a person is or is not a promoter depends upon the facts in each particular case. Only one who has a desire that a company be formed and is prepared to take some important steps to implement it is a promoter. We shall now try and understand the meaning and the definition of the term promoter. So far as meaning of the term promoter is concerned, it means a person who is involved in the promotion of the company. A promoter is a person who does all the necessary preliminary work incidental to the formation or promotion of the company. To be a promoter, one need not be necessarily associated with the initial formation of the company. One who subsequently helps to arrange floating of its capital will equally be regarded as a promoter. The term promoter is a term of business and not of law. It has not been defined anywhere in the previous Act of 1956 but has been explained through a number of judicial decisions and by various jurists. In the words of Lord Justice Bowen, and I quote, "The term promoter is a term not of law but of business, usefully summing up in a single word a number of business operations familiar to the commercial world by which a company is generally brought into existence." According to Justice Cockburn, and I quote, "A promoter is one who undertakes to form a company with reference to a given project and to set it going and who takes the necessary steps to accomplish the purpose." Unquote. Lord Blackburn states that the term promoter is a short and a convenient way of designating those who set in motion the machinery by which the Act enables them to create an incorporated company. According to Palmer, the company promoter is a person who originates a scheme for the formation of the company, has the memorandum and article prepared, executed and registered, and finds the first directors, settles the terms of preliminary contracts and prospects, if any, and makes arrangement for advertising and circulating the prospectus and placing the capital. According to Lord Lindley, and I quote, "The word promoter has no very definite meaning. As used in connection with companies, the promoter involves the idea of exertion for the purpose of getting up and starting a company, or what is called floating it, and also the idea of some duty towards the company imposed by or arising from the position which the so-called promoters assume towards it, unquote. The expression promoter has not been defined under the Companies Act 1956. However, as per Section 2, Clause 69 of the Companies Act 2013, the term promoter is defined. It means a person who has been named as such in the prospectus or is identified by the company in the annual return referred to in Section 92, who has control over the affairs of the company directly or indirectly, whether as a shareholder or a director or otherwise, in accordance with whose advice, directions or instructions the board of directors of the company is accustomed to act, provided that nothing in subclause C shall apply to a person who is acting merely in a professional capacity. Certain attempts have been made by the judiciary to define the term promoter. Cockburn, Chief Justice in the case of Twycross v. Grant, described a promoter as one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. In the case of Boscher v. Richmond Land Company, the term promoter has been defined as, in the case of Boscher v. Richmond Land Company, the term promoter has been defined as, and I quote, "A promoter is a person who brings about the incorporation and organization of a corporation. He brings together the persons who become interested in the enterprise, aids in procuring subscription, and sets in motion the machinery which leads to the formation itself." Lord Justice Brown, in the case of Whaley Bridge Printing Company v. Green, observed that the term promoter is a term not of law but of business. To be a promoter, one need not be necessarily associated with the initial formation of the company. One who subsequently helps to arrange floating of its capital will equally be regarded as a promoter. However, persons assisting the promoters by acting in a professional capacity do not thereby become promoters themselves. In Lagunas Nitrate Company v. Lagunas Syndicate, it was stated that to be a promoter, one need not be necessarily associated with the initial formation of the company. One who subsequently helps to arrange floating of its capital will equally be regarded as a promoter. A person who acts in a professional capacity is not a promoter. Thus, a solicitor who prepares on behalf of the promoters the primary documents of the proposed company is not a promoter. Similarly, an accountant or a valuer who helps the promotion in his professional capacity is not a promoter. But any such person may become a promoter if he helps the formation of the company by doing an act outside the scope of his professional capacity. A person cannot, however, become a promoter merely because he signs the memorandum as a subscriber for one or more shares. In conclusion, it may be said that the word promoter is used in common parlance to denote any individual, syndicate, association, partnership or a company which takes all the necessary steps to create and mold a company and set it going. Dear students, we shall now try and understand the different types of promoters. A promoter is one who envisages an idea for setting up a particular business at a given place and carries out a variety of formalities required for starting a business. A promoter is the one who envisages an idea for setting up a particular business at a given place and carries out a variety of formalities required for starting a business. The promoters may be professional, occasional, financial or managing promoters. The first category is accidental promoters. Some idea strikes to the mind of some persons accidentally and they try to convert it into reality. These are known as accidental promoters. Such promoters do not take promotion as their profession. They try to bring a business concern into existence for their own settlement or for their family. The second category is professional promoters. These promoters take the promotion as their profession and a means of livelihood. They hand over the company to shareholders when the company starts. Unfortunately, such promoters are very scarce in developing countries. They have played an important role in many countries and helped the business community to a great extent. In UK, the issue house, in US, the investment bank, and in Germany, joint stock banks have played the role of promoters very significantly. The third category is occasional promoters. Occasional promoters are those whose main interest is the floating of companies. They are not in promotion work on a regular basis but take up promotion of some companies and then go to their earlier profession. For example, engineers, lawyers, etc. may float some companies. The fourth category is financial promoters. Some promoters who undertake the promotion of the company complete the promotional activities and then purchase the entire share capital of the company promoted. They provide financial certainty and assurance to the company. Later on, they sell the shares at some profit. As they provide and offer the financial services, they are also known as financial promoters. They do the task of promoting the financial institutions. They generally take up this work when the financial environment is favorable at the time. The fifth category is managing promoters. Managing promoters play a significant role in promoting new companies and then getting their managing agency rights. A promoter is neither an agent nor a trustee of the company as it is a non-entity before incorporation. Dear students, we shall now discuss the functions of a promoter. A promoter plays a very important role in the formation of a company. A promoter may be an individual, an association, or a company. In their capacity as promoters, they perform a number of functions in order to incorporate a company and set it going. Some of the functions are: number one, promoters are generally the first persons who conceive the idea of business, and their function is to get the idea of formation of the company. The second function of the promoters is to consult the experts of the field regarding the feasibility of the idea. The third function is to carry out the necessary investigation to find out whether the formation of the company is possible and profitable. The fourth function of the promoter is that they organize the resources to convert the idea into a reality by forming a company. Or in other words, we can say that it is the promoter, number one, who search out the persons who may agree to be the first directors of the company and to sign the memorandum of association. Number two, who settle the name of the company and thereby ascertains whether the name will be acceptable by the registrar's office. Number three, who settles the contents or the details as to the articles of the company. Number four, who nominates the directors, bankers, auditors, brokers and legal experts, etc. Number five, who decides the place where the registered office has to be situated. Number six, who prepares the memorandum of association, the articles of association, the prospectus and other necessary documents and files them for incorporation. Number five, to get the certificate of incorporation. Number six, to get the permission and to arrange for the issue of the capital. Number seven, if the company has to purchase a going concern business, to finalize the purchase of such business. Number eight, to prepare and enter into contracts with underwriters, vendors, brokers and managing agents. Number 9, to collect the amount on the issue of share capital. Number 10, to get the certificate of the commencement of business. Number 11, to pay the preliminary expenses. 12, to appoint the requisite personnel for the whole process. In this sense, the promoters are the originators of the plan for the formation of a company. To secure the cooperation of the required number of persons willing to associate themselves with the project, the promoters, in accordance with whether they want to incorporate a private or a public company, try to secure the cooperation of the persons needed to form the company. Minimum number of persons required to form a public company is 7, and that for a private company, the minimum number is 2. Depending the form chosen, the promoters may decide upon the number of primary members. To sum up, The promoters perform all the activities right from the idea in his mind to the commencement of the business by the company. He gets the company established, and after the establishment of the company, he comes out of the picture and lets the company go on with its business. Dear students, we shall now try and understand the rights of promoters. The promoters, being in a fiduciary relationship with the company they form, have certain rights and liabilities vis-à-vis the company. The rights of the promoter of the company are: number 1, right to receive preliminary expenses. The promoters are entitled to receive all the expenses incurred in setting up and registration of the company. The articles may provide for payment of preliminary expenses to the promoters. The company may pay the expenses to the promoters even after its formation, but such payments should not be ultra vires the articles of the company. The relevant case on the point is that of Malhado versus Porto Alegre Railway Company. In this case, the articles of the company contained a provision that the company may make payment of the expenses incurred for setting up of the company to the promoters. The quantum of expenses to be paid depended on the decision of the board of directors, but it was not to exceed £2,000 in any case. The plaintiffs were the promoters of the company who sued it for the enforcement of payment on the basis of the articles. The court ruled out that the promoters could not sue the company for preliminary expenses, as the company is not bound by any provision in the articles except to the members in their capacity as members. Number 2, the right to indemnity. The promoters are held jointly and severally liable for the secret profits made by them in the formation of the company. Therefore, if the entire amount of secret profits is paid to the company by a single promoter, he is entitled to recover the proportionate shares from his co-promoters. Likewise, if the entire liability arising out of misstatement in the prospectus is borne by one of the promoters, he is entitled to recover proportionately from the co-promoters. Number 3, the right to receive remuneration. A promoter, having made proper disclosure, has a right to be paid remunerations for his efforts. The payment of the remunerations to a promoter in consideration of his service may be paid in the form of fully or partly paid shares, debentures or commissions, or it can even be in the form of lump sum amount. It must, however, be pointed out that in the absence of any express agreement with the company after its incorporation, a promoter is not entitled to claim from the company any remuneration for his services. A company is also not liable in the absence of an agreement to reimburse a promoter in respect of registration fee or stamp duty paid by him for the registration of the company. Whatever may be the remunerations or the benefit paid to the promoter, it must be disclosed in the prospectus if it is paid within 2 years preceding the date of the prospectus. Dear students, we shall now try and understand the duties of a promoter. The Early Companies Act contained no provisions regarding the duties of the promoters, and even today legislation is largely silent on the subject, merely imposing liability for untrue statement in listing particulars or prospectuses to which they are parties. The promoters have certain basic duties towards a company formed. Number 1, to stand in a fiduciary relationship. As we know that the promoters have been described to be in a fiduciary relationship, that is, a relationship of trust and confidence with the company. This relationship of trust and confidence requires the promoter to make a full disclosure of all material facts relating to the formation of the company. Number 2, to disclose all secret profits. He must not make any secret profit out of the promotion of the company. Secret profit is made by entering into a transaction on his own behalf and then sell the concerned property to the company at a profit without making disclosure of the profit to the company or its members. The promoter can make profits in his dealings with the company provided he disclose these profits to the company and its members. What is not permitted is making secret profits, that is, making profits without disclosing them to the company and its members. The next duty is to disclose all material facts. He must make full disclosure to the company of all relevant facts, including any profit made by him in any transaction with the company. Another duty of the promoter is to make good to the company what he has obtained as a trustee. A promoter stands in a fiduciary position towards the company. It is his duty to make good to the company what he has obtained as a trustee. This was stated by Lord Dunlin in Jubilee Cotton Mills Limited case. The next duty of the promoter is to disclose private arrangements. The promoter should disclose all the private arrangements which he entered into or got by the promotion of the company. Dear students, we shall now discuss the liabilities of a promoter. A promoter can be compelled by the company to hand over any secret profit which he has made without full disclosure to the company. The company can also sue for the rescission of the contract of sale by the promoter where the promoter has not disclosed his interest therein. A promoter is also subject to certain liabilities under the various provisions of the Companies Act. These are: number 1, Section 26 of the Companies Act 2013 lays down the matters to be stated and reports to be set out in the prospectus. He may be held liable for the non-compliance of the provisions of this section. Under Section 35 of the Companies Act 2013, a promoter is liable for any untrue statement made in the prospectus to a person who has subscribed for any shares or debentures on the face of the prospectus. Such a person may sue the promoter for compensation for any loss or damage sustained by him. Any false statement in the prospectus may lead to certain consequences. These are: number 1, the allotment of shares or debentures may be set aside. Number 2, the promoters may be sued for damages and also for compensation. Number 3, the promoters may incur criminal liability and criminal proceedings may be instituted against them. Besides civil liability, the promoters are criminally liable under Section 34 of the Companies Act 2013 for the issue of prospectus containing untrue statements. Section 68 imposes severe penalty on promoters who make untrue and deceptive statements in a prospectus with a view to obtaining capital. The promoter may, however, escape liability if he proves that he had reasonable ground to believe that the statement was true or the statement was immaterial from the point of view of attracting the investors. A company may proceed out against the promoter for deceit or breach of duty under Section 543 where the promoter has misapplied or retained any property of the company or is guilty of misfeasance or breach of trust in relation to the company. The court may restrain a promoter from taking part in the management of the company for a period of 5 years if it appears that he has been guilty of offence punishable under Section 339, whether he has been convicted or not, or while being an officer of the company has otherwise been guilty of any fraud or misfeasance in relation to the company or committed any breach of duty in respect of the company of which he is the promoter. If the company is wound up by the order of the court and the liquidator's report alleges any fraud in the promotion and formation of the company, the promoter or the promoters shall be made liable to public examination like any other officer or director of the company. In the event of the death of the promoter, the company may recover the damages or compensation from the property of the deceased promoter. So, a promoter is liable to the original allottee of shares for misstatements contained in the prospectus. It is clear that his liability does not extend to subsequent allottees. He may also be subject to imprisonment for a term which may extend up to 2 years or may be punished with a fine of up to ₹50,000 for such untrue statements in the prospectus. Dear students, we shall now try and understand the legal position of the promoter in relationship to the company. The legal position of promoters has been explained by Lord Keynes in Erlanger versus New Sombrero Phosphate Company, and I quote, "They, the promoters, stand, in my opinion, undoubtedly in a fiduciary position. They have in their minds the creation and the moulding of the company. They have the power of defining how and when, in what shape and under what supervision the company shall start into existence and begin to act as a trading corporation." Unquote. Elaborating on the legal position of promoters, Lord Justice Lindley in Lydie and Wigpool Iron Ore Company versus Bird observed, I quote, "A promoter is neither a trustee nor an agent of the company, which he promotes because there is no trust or principle in existence before the formation of the company and at the time of his efforts, but the old principles of the law of agency and of trusteeship have been extended and very properly extended to meet such cases. A similar view has been expressed about the position of the promoters in Lagunas Nitrate Company versus Lagunas Syndicate, wherein the court held that the promoters hold a fiduciary position in relation to the company he promotes. He is neither an agent nor a trustee for the company because the company before incorporation has no legal existence. Certain fiduciary duties, like an agent, have been imposed on him under the Companies Act also. As such, he is said to be in a fiduciary position, a position full of trust and confidence towards the company and the original allottees of the shares. Consequently, a promoter must make full disclosure of the relevant facts, including any profit made. He must not make any secret profits out of the transaction he makes on behalf of the company. It is to be observed that it is not the profit made by the promoter which the law forbids, but the non-disclosure of it. If full disclosure is made to an independent board of directors or to the shareholders as a body and not to a selected few, the profit is permissible. A promoter vendor cannot evade his liability of disclosure of profits by disclosing to a board of directors who are mere nominee of his own or in his pay. A good illustration on the point is to be found in Gluckstein versus Barnes. In this case, a syndicate of persons was formed to purchase the Olympia company and to promote and register a company to which the Olympia property was to be resold. The syndicate first bought the debentures of the Olympia company at a discount. Then they bought the company for £140,000, out of which this money provided by them, the debentures were repaid in full and a profit of £20,000 was made thereon. They promoted a new company and sold Olympia to it for £180,000. The profit of £40,000 was revealed in the prospectus, but not the profit of £20,000. It was held that the profit of £20,000 was a secret profit made by the syndicate as the promoters of the company, and they were bound to pay it to the company, which was at that time in liquidation. On behalf of the syndicate, it was argued that they had in fact made a proper disclosure, but it was turned down on the plea that the disclosure made by them in the capacity of vendors to themselves in the capacity of directors of the purchasing company was not sufficient. The disclosure ought to be made to an independent board or to all the shareholders by means of a prospectus. Dear students, this is all with regard to promoters. In this lecture, we try to understand the meaning of the term promoter. We also try to understand the rights and liabilities of the promoters. We also try to understand the legal position of the promoter vis-à-vis the company. This is all with regard to the lecture today. Hope you have understood fully. Thank you and stay blessed.